So good morning, everyone, and welcome to the first of our HRLaw webinars for 2023. I'm Jo Chatterton, head of the Employment and Immigration team here at Fox Williams. We will be continuing with our webinar format this year, so there will be further webinars to come in May and November. And a few admin points I wanted to mention just before we start this particular session. The webinar will be recorded and it will be available to those people who can't join us this morning. We are very happy to take questions on the topics which we're discussing today. If I could ask you please to put those into the Q&A box rather than the chat box, and we'll be able to cover these at the end of the session once the speakers have finished in the time that we have available. On which note, I'm really delighted today to introduce you to my three colleagues and all speakers today, all of whom who joined our team last year. So this is the first HRLaw webinar appearance for each of them. Imtiaz Chowdhury, who's an associate in the team, will be discussing first the employment law trends that we expect to see over the course of this year. He will then hand over to Lucy Sorrell, who's our new legal director, and she will discuss the impact of several recent employment cases and also upcoming cases that we expect to see in 2023. And then finally, Lucy Sellen, who is an associate in our team, will talk about the government's legislative agenda this year. There's certainly been a flurry of activity with 5 private members' bills progressing through Parliament and soon to join the statute books, alongside, of course, the much criticised retained EU law reform and revocation bill. The extent of its potential impact on UK law is still not entirely clear. So it remains, of course, to be seen whether 2023 will be as turbulent as last year. We can only hope not, but employers are certainly still wrestling with the economic upheaval. While many of you will be thinking about how best to support your existing staff through the cost of living crises, there are also business headwinds to think about, which in some cases, as we're already seeing in our practice, may be leading to restructuring and potential redundancies. It's not all doom and gloom. I think employers are increasingly aware of the benefits that focusing on diversity and inclusion can bring. And what we can see is that's resulting in positive culture changes within organisations. And we see that as a continuing positive theme through the year. So with that, I'm going to hand you straight over to Imtiaz to discuss those trends in more detail. Thank you.
Thanks, Jo. So today I'll be talking about the key employment law trends that we're expecting to see this year. Next slide, please. And the first is one that I'm sure we're all familiar with. The implications of the cost of living crisis have continued into this year and are ongoing. This has been on the radar for many employers for some time, but I think it's a theme that will continue to resonate this year. So I'm going to talk about ways to support existing employees, as well as the prospect that some employers are facing of having to restructure and make redundancies in light of economic headwinds. This year's round of pay reviews will also be an interesting one. Many employers recognize the need to link pay rises to inflation last year, and employees may well be expecting a similar approach this year. Now, in many cases, employment contracts will make it clear that there is no legal obligation to make pay rises, which will be helpful if an employer is not in a position to do so. But it would be wise to manage employee expectations to minimize the risk of objections and potential disputes. Looking at the national living wage, for example, it will increase in April to £10.42, which is nearly 10% up from last year. Employees may have set their sights on a similar approach in terms of salaries, particularly if market conditions mean that performance bonuses will be reduced or non-existent. In recognition that many employees are struggling to address financial pressures, some employers have taken the approach of making one-off top-up payments to staff, with the view to helping them through the cost of living crisis. Although immediately helpful, it can also have a positive effect on morale and possibly even loyalty over the long term, with staff feeling supported and valued by the company. We have seen some employers only making these one-off payments for staff earning up to a certain salary level. Now, although this ensures that employers are able to support those who may need the financial support most, employers should ensure they do not exclude employees who are absent from work for a specific reason. For example, those who are on long-term sick or on maternity leave or shared parental leave. This would avoid suggestions being made that the employer has been discriminatory in its approach of offering one-off payments. Next slide, please. Another source of saving could be subsidized benefits offered by employers, such as free breakfast and meetings, subsidized canteens, or health and well-being classes that save on gym memberships. Now, all of these benefits are likely to be well received by staff at a time when disposable income is squeezed. One positive factor is that hybrid working can also present a chance to save money. Travel costs are expensive, so the option to work from home more often may result in a saving on that front. However, the rising heating costs could also have the opposite effect for some people, with staff hoping to take advantage of warm, comfortable office environments, rather than add to their own bills by working from home. It's important to ensure the office is still geared up to accommodate all staff at once, if that's the case. Another employee benefit that we have seen is the option for employees to sell back some of their contractual holiday. This could be seen as a good idea if it helps employees financially, as the extra money they receive could support them with their day-to-day costs or address ad hoc costs such as high energy bills. However, employers need to consider their health and safety obligations to their employees. Employers have a duty of care to their employees, and so they should be mindful that employees are able to take holiday and take a break without feeling as though they need to give up their holiday because they are facing tough financial circumstances. And that brings me to my next point, which is that many employees are now taking up second jobs. This is becoming increasingly common, and we expect it to become more so if the current economic state doesn't improve. These second jobs tend to be roles that they can do in their spare time, either in the evening or on weekends, to help manage their financial circumstances. This could, however, mean that employees are much more tired because of their overly long working hours, which only further raises the profile on the employer's health and safety obligations to their employees. Employers will need to be even more attuned to the welfare of their staff in these circumstances. Now, all of these circumstances will undoubtedly have an impact on the mental health of employees. This is something that employers need to be mindful of as part of their health and safety obligations. They need to keep an eye on their staff and ensure that their mental health is not at detriment because of the cost of living crisis. And if it is, they need to find some way to support their staff. Next slide, please. I will now turn to the implications for employers as a result of the cost of living crisis. Now, as costs rise, the key issue for employers is how to manage these costs from a business perspective and an employee perspective. Naturally, supplier costs will rise, and so will the expectations of employees to receive increased salaries, bonuses, and one-off payments. As a result of these increased costs across the board, we expect there will be a rise in restructuring and redundancies this year as employers struggle to keep up with the volatility of the economic circumstances. Employers will seek to justify the redundancies and restructuring based on business necessity. They need to be able to continue operating, and restructuring their business or proceeding with the redundancies may be the only way for them to do that. However, for some employers, this would also be an opportunity for them to reduce their workforce and save cost, something which they may have planned already in order to continue operating efficiently. But redundancy must be genuine, otherwise employers will face significant legal risks. The legal position of redundancy is clear. For example, the redundancy is needed because of the closure of the business, because a specific site of the business is closed, or there is a reduction in the requirement for employees to do work of a particular kind. If the redundancy is in response to the cost of living crisis, this could be any one of those reasons. The redundancy has to meet the legal requirement, and it must not be a dismissal dressed up as a redundancy. Now, businesses need to be mindful of a number of factors before proceeding with redundancies, which I'll talk through quickly now. What are their business reasons for proceeding with the redundancy? For example, is there a significant market downturn, which has meant that their revenue has been and will continue to be impacted, therefore justifying the reduction in the workforce? How many employees will be impacted by the redundancy? Is it several individuals, or are there 20 or more employees that you're proposing to make redundant? If there's 20 or more, and employers are proposing to make them redundant within a 90-day period, then that is classified as a collective redundancy, and there are separate requirements on this, including in respect of the consultation process. Employers must at all times be transparent with their staff about the redundancy procedure. They need to have a plan in place from the outset as to how they would address the redundancy selection and consultation process. If they are not transparent, there are legal risks for them, which could ultimately become more costly for them to address, as opposed to the cost involved in planning for a robust redundancy process. The consultation process needs to be managed properly and in a genuine way, which will need to include considering whether there are any alternatives to redundancy or alternative roles available. The redundancy has to involve a fair selection process. Employers need to be able to mitigate the risk of employees claiming that their redundancy wasn't genuine, or, for example, there was discrimination involved in the selection process. Again, planning for the redundancy process is paramount in mitigating these potential legal pitfalls. And finally, employers will have to consider the redundancy package to be offered to employees. Of course, there is a statutory redundancy payment to think of where the employee has worked for 2 years and more, but employers may want to consider an enhanced redundancy package being offered to employees if they agree to a settlement agreement. This could be helpful in mitigating potential legal claims being raised by the employees. Next slide, please. Now we turn to flexible working, which has seen a lot of focus recently. The Employment Relations Flexible Working Bill was introduced to give employees more flexibility as to how they work and when and where they carry out their work. The right exists from the commencement of employment. There is no requirement that an employee has to complete 26 weeks of service before they can make a request for flexible working. The number of requests they can make in any 1 year has also doubled to 2 requests. The onus on employers is an interesting feature of this new law, as there is a focus on employers turning their mind properly to such a request from an employee. For example, there is a shorter time frame of 2 months for employers to respond to the request rather than 3 months. Employers must also consult on alternative options to the request instead of simply refusing it. Now, although this indicates that employers will find it more difficult to reject a request, this may not be the case in practice, as they still have a wide scope to refuse a request based on the 8 statutory grounds for rejection. It was already possible for employees to request a temporary flexible working arrangement, and now there is also guidance on this, as temporary requests were not much utilized in the past. This may become more common as employees seek to arrange flexible working arrangements for specific reasons. And there could very well be a rise in the flexible working requests throughout this year and beyond, as employees may focus on how best to fit work around their lifestyle, which has certainly become more common since the pandemic. That being said, there is a feeling that all of those employees who wish to make a flexible working request have already done so. They're the individuals who made the request since the pandemic and its effects. So in fact, there may not be a huge uptake in flexible working requests after all, but we will just have to wait and see. Next slide, please. We're now looking at a new trend of addressing workforce shortages. Now, although we're seeing market downturn as part of the cost of living crisis, there is a parallel issue of economic inactivity due to employees not being in work. There are a number of reasons for this, but some of them are because employees are on long-term sick, with their return to work remaining uncertain, or they're choosing to retire early. This does not help the current economic environment, as it results in a shortage in the workforce, with employers seeking to entice staff using higher salaries and one-off lump sum payments. Employers who are struggling with the reduction in their workforce could take certain action to address this situation. In relation to staff who are sick, a sickness absence support strategy could be developed, which might include, for example, a focus on individual reasonable adjustments, a phased return or reduction in the scope of role, harnessing the benefits of flexible hybrid working, such as the ability to work from home if commuting is difficult, or even occupational health support to provide recommendations. In terms of staff who are looking to retire, employers will need to incentivize them to stay. Now, this could be a financial incentive, or in fact, it could be by way of accommodating a flexible working request to allow them to focus on their lifestyle, yet keep them in employment. There's also the option of asking those who have retired to return. This doesn't need to be by way of full-time employment, but could, for example, be in the form of a contractor engagement. For those who have retired, they may need specific support to help them return, such as support with their health by way of making reasonable adjustments, or providing them with training to enable them to return to work. These options should be considered by employers. The government is also offering what it calls a midlife MOT to workers who are in their 50s to help them gain perspective on their finances, skills, and health and allow them to better prepare for their retirement. This scheme is being developed in the private sector and also through job centres. The scheme might actually help those workers who are considering retirement to take up employment, as they may have worried about barriers to employment before undergoing a financial MOT. Employers might also find that retaining staff could be achieved by offering better benefits, which, for example, could be private medical cover or an enhanced life insurance coverage. Now, one factor that employers must not overlook in thinking about how to retain staff is their culture. Time and time again, we've seen employees leave employers because of either a negative working environment and culture or a lack of culture whatsoever. This is not helpful to staff and is a key reason why employees leave, which is a direct impact on the shortage of workforce issue. Employers need to be mindful of creating a positive and inclusive working environment, which would also lead to addressing issues in the workplace such as harassment or discrimination. Employers need to seek to prevent these events from occurring, both due to their legal duties to their employees and to mitigate the risk of legal action being taken against them, and also because otherwise it would only further contribute to the workforce shortage issue. Next slide, please. And finally, return to diversity and inclusion. Now, we've been talking about diversity and inclusion for some time now, but the start of the year is always a good time for employers to remind themselves of how important it is to maintain momentum with diversity initiatives. It's still on the agenda for many regulators. We're expecting a final policy statement from the FCA at some stage this year, so financial services employers should be looking out for that, and we will be involved in events and publishing articles on the topic. I also think this year employers will start to branch out with their approach to diversity. Historically, there was a tendency to think about it in terms of underrepresented groups with a protected characteristic under the Equality Act. For example, women, LGBTQ employees, or disabled workers. That is still the case, but employers are also becoming aware of including a broader spectrum of society, whether that encompasses social mobility or neurodiversity, for example. In terms of the best approach to take, the CIPD has offered some guidance in a recent report published in December last year. They conducted a survey of 2009 senior executives with some interesting conclusions. Only 48% had a freestanding diversity and inclusion strategy in place, for example. Further, 36% of respondents said that their business was not planning to focus on any diversity and inclusion areas in the next 5 years. This is quite a surprising statistic given the amount of publicity and discussion about this area over recent years. The report is worth a read because it makes 7 key recommendations. Now, I've included these on the slide, and there's nothing new in there as such, but all useful reminders for the role that the HR team can play to make sure that diversity and inclusion progress remains a top priority for the business. For example, the importance of monitoring progress so that you can see whether what you're doing is working or whether a different approach is needed. Also, employers really need to empower and train their managers on diversity and inclusion. The managers, after all, are the individuals who will ensure that the organization as a whole understands and implements a diverse and inclusive working culture. This is really a key recommendation. That's it from me. Thank you for listening. I'll now hand you over to Lucy.
Thanks very much, Imtiaz. So I'm going to talk about 3 key recent employment cases and their implications. So if we could go to the next slide, please. So this case is all about the extent to which settlement agreements can waive claims which aren't known to the parties at the time that that agreement is entered into. So in this case, the claimant volunteered for redundancy in January 2017. And at that time, he signed a voluntary redundancy agreement settling claims against his employer, including claims of age discrimination. There was also a general waiver of future claims, whether known or unknown to the parties at the time of signing. Under the agreement, Mr. Bathgate stood to receive an enhanced redundancy and notice payment to be paid with his last salary payment. And on top of that, he was meant to receive an additional payment to be made in June 2017. And this payment was governed by the terms of a separate collective agreement, which included the discretion not to pay out to employees over 61 years old. And that was Mr. Bathgate's age at the time of signing the agreement. In March 2017, so just 2 months after the agreement was signed, it was decided by the employer, Technip, that discretion would be exercised not to make this payment to employees who are over the 61 years of age threshold. So that meant that Mr. Bathgate would then not receive his payment. When June 2017 came around, Mr. Bathgate didn't receive the additional payment under the settlement agreement, and he brought a claim for age discrimination because although he'd signed the settlement agreement waiving those claims, the claim hadn't existed when the settlement agreement was signed. It came into existence 2 months later when the decision was made not to pay him. We could move to the next slide, please. So the EAT had a look at this case and it in particular considered the statutory requirement within the Equality Act that a settlement agreement relates to a particular complaint. And it said that this wording, particular complaint, meant a complaint that was identifiable by the parties at the time of signing. And it followed from that principle, said the EAT, that settlement agreements can't waive hypothetical claims which might arise in the future and aren't known to the parties at the time that they sign the agreement. In coming to that conclusion, the AAT looked at previous decisions, some of which seemed to suggest that future unknown claims may be settled if plain and unequivocal language was used. And these decisions were distinguished for a number of reasons, but the major one was that in these cases, at the time of signing, grounds for a claim existed even if the claim itself wasn't yet on foot, and the person signing up to the agreement knew about the facts giving rise to the claim even if they hadn't brought the claim yet. This case was different because at the time of signing, the events giving rise to Mr. Bathgate's claim hadn't yet occurred because he signed the agreement in January and the decision not to make the payment to him wasn't made until March. The fact that Mr. Bathgate's settlement agreement mentioned age discrimination as one of the claims to be waived didn't help the employer in this case because the intention of the statutory requirement around having a particular complaint was to prevent individuals from signing away their rights to bring claims that they didn't know and couldn't know that they had. And so it therefore couldn't be right that the legislation operated to prevent Mr. Bathgate from bringing a claim before the facts giving rise to his claim had occurred. And that all meant that the age discrimination claim could proceed. We can move to the next slide, please. So just to look at where that leaves us in terms of settlement agreements and their effectiveness at waiving future claims, we now have conflicting EAT decisions on whether it's possible to waive future claims which aren't known to the parties at the time of signing. It's possible that employment tribunals will prefer this case, and so that means that there's a possible health warning around the ability of settlement agreements to waive claims which are not known about at the time of signing. In most cases, that won't matter because 9 times out of 10, the grounds for claims already exist at the time of signing and the relationship is brought to an end. And where that isn't the case, there will often be a re-signing at the end of someone's notice period if there's a gap between signing and termination. But if for any reason that's not the case, it might be better to rely on a COP3 agreement instead of a settlement agreement, which the other EAT case of Arbanescu suggests could be effective to waive this type of claim. I think this case also does underline the importance of spelling out each claim that you'd like to waive upon termination, and also to review any existing templates to make sure that they make provision for this. And I think it also underlines the importance of having a re-signing of the agreement where there's a gap between signing and termination because of things which can arise during that time and which you need to make sure you settle again at the end. At the moment, we think that market practice is unlikely to change significantly, so we don't think that this means that we need to stop including waivers of future claims, which are the standard now, but they do come with a bit more of a health warning, and you need to pay attention to what you do and what decisions you make once someone has left employment. So if we could move to the next case, please. This case is about redundancy selection criteria. So it concerned two nurses working in an NHS trust, both of whom were on fixed-term contracts. And the claimant, Miss McGann's contract was set to expire earlier than the fixed-term contract of the other nurse. The need to cut costs arose, and the trust felt that there was a redundancy situation, and it pulled together these two nurses for selection for redundancy. The selection criteria that it used included the date of expiry of the respective fixed-term contracts, and a lower score was given to Ms. McGann because her fixed-term contract expired earlier. And the trust didn't consult with the two nurses on the selection criteria, so it pulled them together, applied this selection criteria, and then when Ms. McGann was selected, it then began to consult with her on the proposal and its rationale and on alternative employment, but no alternative employment could be found, and she was dismissed. She brought a claim for unfair dismissal, and that failed at the first instance, so she then appealed to the EAT. And if we could have the next slide, please, we can look at the decision. So the EAT said that the unfair dismissal claim should succeed. It said that the principles of fairness for collective redundancy should also apply to individual redundancy. And in doing so, it emphasised that consultation should be taking place at a formative stage when there's a chance for the employee still to influence the outcome. That hadn't happened in this case because the choice of selection criteria used by the trust, so the point in time at which the fixed-term contracts expired, led to the inevitable conclusion that the claimant should be selected. And because she hadn't been consulted on the choice of selection criteria, she hadn't been able to influence the outcome. And I think to add insult to injury here, the decision to use that selection criteria was quite arbitrary, and the trust hadn't been able to justify not consulting on it, and I think it hadn't been able to justify the criterion itself. And all of that meant that Ms. McGann was effectively chosen for dismissal before any consultation took place. So in terms of the takeaways, this doesn't necessarily mean that you always need to consult about any selection criteria that you're going to be applying. Each case will still turn on its individual facts. In this case, because the selection criteria chosen meant that the decision inevitably went a certain way, consultation on the criteria would have been appropriate, but that won't always be the case. I think in all cases, though, you need to make sure that you can justify your selection criteria and that you can't be accused of engineering a particular outcome. And if you decide not to consult on the selection criteria, perhaps think about in advance how you will justify that if that gets challenged during the consultation process, particularly in light of this case. So that was that case. If we could move to the next slide, please, to look at the last one. So this case deals with when a grievance, and specifically a without prejudice conversation within a grievance, will be genuinely without prejudice. So first of all, a quick reminder about what without prejudice means. It means that a discussion with the label without prejudice can't be put on a record or used at a court or tribunal in evidence. It must be a genuine attempt to settle a pre-existing dispute between the parties. So it allows the parties to agree payment terms off the record that won't be put before a court or a tribunal. So when we think about what a pre-existing dispute is, we might think that just because someone raises a grievance, that means that a dispute is in existence. But the act of raising a grievance doesn't necessarily in and of itself set up a pre-existing dispute for those purposes. So we've got to be a bit careful about when we say a pre-existing dispute has been set up and for those purposes, whether or without prejudice conversation can then take place. Another thing which can threaten the without prejudice status of a conversation like this is if there is any kind of impropriety, and this was a relevant factor in this case. So if it appears, for example, that the employer has put the employee under pressure to agree to a settlement, or perhaps threatens them that if they don't agree to the settlement, there'll be adverse consequences for them, such as the termination of their employment, that could mean that with discussions no longer without prejudice. So if we move to the next slide, please. This issue came up in the case of Garrett and Riverstone Management. So in this case, a company secretary raised a grievance about discrimination following her return from maternity leave. and there was a grievance meeting which was held by an external HR advisor. And during that meeting, there were kind of more details shared about the grievance. And at the end of the meeting, the employer went into a without prejudice section, as part of which it made an offer to settle the discrimination complaint within the grievance. The offer was that the individual's employment would terminate on amicable terms and that she would receive a financial settlement package of £80,000. The employee rejected the offer and she went on to bring a claim, and in her particulars of claim, she referred to the settlement offer. And she felt that because one of the terms of the offer had been that her employment would terminate, the employer was retaliating against her for raising a grievance. And this was the kind of impropriety that threatened the without prejudice status of the compensation. So there was a dispute about whether this compensation could be referred to. We can move to the next slide, please. The Employment Tribunal agreed with the employer that the settlement offer was indeed without prejudice, and it disagreed with the employee that there was unambiguous impropriety. It stressed that that was quite a high bar. It would only apply in exceptional circumstances, probably in cases where the company kind of puts pressure or blackmails the employee into accepting a particular offer rather than proceeding with an internal process. In this case, the employer was simply offering an alternative to going through the grievance process, as part of which the employee and the employer would agree to part ways. And that may have been interpreted as retaliation for raising a grievance by the employee, but the tribunal was satisfied that it was actually just a proposal by the employer, and that termination was one of the without prejudice terms. It also felt that a pre-existing dispute was in existence at the point that the grievance was made, because the employee went on to bring a discrimination claim, the sort of facts of which she had already brought into the grievance that she then brought. So the dispute was on foot at the point that the grievance meeting was held. And that meant that there was a pre-existing dispute for without prejudice purposes. In terms of the takeaways, we should still exercise caution when we're having these types of discussions during open processes. A settlement offer might be without prejudice, but the context of the grievance meeting will be key. And it's very important to make sure that when you have that without prejudice conversation, you avoid any suggestion that there's pressure on the employee, because that could threaten the without prejudice status of that conversation. So the employer needs to be very careful about how they position an offer, and if they don't do that correctly, that could muddy the waters. So the right choice of wording is very important here. So if we could just go to the next slide. This is the final one, and I'm just going to mention a few cases which are coming up for hearing in 2023, which I think will be important to look out for. So the first case is about holiday pay, and it's Chief Constable of Police Service of Northern Ireland and Agnew. We're waiting for the Supreme Court decision on that, but that's around the point that a series of unlawful deductions for holiday pay purposes isn't broken if they occur more than 3 months apart. So that's quite an important point of law for holiday pay purposes, and the value of holiday claims and which payments you can bring into a claim for a series of unlawful deductions. So we'll await that with interest. There are then 3 different cases relating to religion or belief discrimination. And interestingly, these are all kind of thematically linked, because they all relate to the conflict of beliefs and the gender debate, and specifically gender critical beliefs. So the case of Higgs and Farmer, so that concerned whether it was correct to hold that a Christian employee's beliefs that gender can't be fluid and that an individual can't change their biological sex or gender are worthy of respect in a democratic society, and therefore capable of being protected beliefs under the Equality Act. Then there's the case of Macris and the Department of Work and Pensions, whether the Employment Tribunal was correct to find that a doctor who was carrying out health assessments for the DWP wasn't discriminated against on the grounds of religion or belief when he was suspended and dismissed for refusing to address transgender patients by their chosen pronoun. And finally, the Bailey and Stonewall Equity case. So this was about a barrister who succeeded in an employment tribunal claim that her chambers had discriminated against her for holding gender-critical beliefs and expressing misgivings about Stonewall's policy aims. But she also brought a claim against Stonewall. And so the appeal is all about whether Stonewall could have instructed or induced discrimination by the barristers' chambers or attempted to do so by sort of expressing concern about the claimant's beliefs. So they're all really interesting cases to look out decisions on, and might give us some clues as to where the sort of jurisprudence is going in relation to the question of the gender debate. So that's all from me, and I'm going to pass on to Lucy Sullen.
Great, thank you, Lucy, and good morning, everyone. So I'm going to talk about the new employment law that we expect to be introduced over the next year and beyond. Can I have the next slide, please? So you may have noticed that there was no mention of a standalone employment bill during the Queen's speech last year, and it appears that the government's lost appetite for it. This is disappointing, particularly for us employment lawyers, because we were hoping for some clarity after the various consultations and government proposals that have been made over the last few years. But instead, what we seem to have now is an employment bill by the back door. So many of the relevant legal protections that were originally going to be included in the employment bill are now developing through private members' bills instead. And these bills have already been introduced to Parliament last year, and the government's confirmed that it's supporting them. So I've mentioned on the slide the 5 key bills from an employment perspective. Imtiaz has already discussed the flexible working bill, so I'm going to focus on the other 4. Just quickly though, on the flexible working bill, we've had a couple of questions about when this is going to come into force. And unfortunately, we can't give a precise date, but in terms of the stage that it's at, it's awaiting its 3rd reading in the House of Commons, and it still needs to go through the House of Lords. So these things kind of do tend to take some time to pass through. The key thing to note is that it will come into force straight away on the day that it's passed. So it's definitely one to keep an eye out on for that reason. And similarly, the timescale for the other new rights also isn't currently clear. Each of the bills are at the report stage, so they still need to go through the House of Commons. And many of the new rights will also need secondary legislation, in other words, regulations, to give effect to the proposals. So some of the changes could be introduced in 2023, but most of the reforms are unlikely to come into effect until 2024. And next slide, please. So starting with protection from harassment, the Worker Protection Amendment of Equality Act 2010 bill introduces 2 key new protections from harassment. So the first is employer liability for third-party harassment of its employees, and the second is a duty on employers to take reasonable steps to prevent sexual harassment. Now, previously, employers were vicariously liable for harassment of their employees by third parties, but that was actually repealed in 2013. But this bill reintroduces that liability, so employers will potentially be liable if they fail to take all reasonable steps to prevent the harassment of their employees by third parties in the course of their employment. And third parties is defined widely in the bill as a person other than the employer or a fellow colleague, a fellow employee. So it will, for example, cover customers, clients, and suppliers. And unlike the previous protection, there will be no need for previous incidents of harassment to have occurred. So liability can apply immediately to the first acts of harassment. So if, for example, a client of the employer harasses an employee during a meeting in the office, then that would be covered and the employer could be potentially liable. It also applies to all of the protected characteristics. So this isn't limited to sexual harassment. So harassment on the grounds of race, age, or disability, for example, would also potentially trigger liability for employers. Now, as I mentioned, there'll also be a standalone duty on employers to take all reasonable steps to prevent the sexual harassment of employees. And the purpose of this is to shift the focus from towards prevention rather than reaction. And a new Equality and Human Rights Commission statutory code of practice is going to be published in conjunction with the new law. And it seems this is going to work in a similar way to the ACAS code on disciplinary and grievance procedures. So employees won't actually be able to bring a separate standalone claim for this, but if they're successful in bringing a sexual harassment claim under the Equality Act, then a tribunal has the power to uplift compensation by up to 25% if there's been a breach by the employer of the new preventative duty. The Equality and Human Rights Commission will also have the power to bring separate enforcement action against employers for breach of this new duty. So that's things like investigations or issuing unlawful act notices or compliance notices. But we imagine that that's going to be reserved for particularly serious cases. Employers have got a bit of time to prepare for this one because the bill says that its main provisions won't come into force until 1 year after it's been passed into law. But in the meantime, as a reminder, there's the Equality and Human Rights Commission guidance from 2020, which suggests the practical steps for employers to take to prevent harassment. And that's things like ensuring policies are up to date and widely accessible, keeping a central record of harassment complaints to allow for analysis, and training staff in the different types of harassment that apply and how to deal with incidents. Next slide, please. So moving on to redundancy protection, the Protection from Redundancy, Pregnancy and Family Leave Bill has arisen out of the response to the government consultation back in 2019 on extending redundancy protection for pregnant women. So as many of you will know, under the current law, before making an employee on maternity leave, shared parental leave or adoption leave redundant, employers are obliged to offer them a suitable alternative vacancy where one exists in priority to anyone else who is provisionally selected for redundancy. And this bill extends the redundancy protection beyond the period of maternity, adoption and shared parental leave to cover the period of pregnancy and the months immediately following a return to work after family leave. So the protection will apply for when a woman first tells her employer she's pregnant until 18 months after the birth. And that 18-month window ensures that a mother who's returning to work from a full year of maternity leave can receive 6 months additional redundancy protection. And similar provisions are also going to apply in respect of adoption leave and shared parental leave. Now, key point to remember here is that protected employees can still be selected for redundancy, but it just means that they have priority over other employees for any suitable alternative vacancies. So from a practical perspective, employers should ensure that line managers in particular are aware of the increased period of protection in terms of offering suitable alternative roles as part of a restructuring process. Policies may need updating and refresher training would also be a good idea. And this new protection is going to come into force 2 months after the bill is passed into law. Next slide, please. So the other two private members' bills that I wanted to mention today are on the slide there. I'm not going to go into too much detail on these, particularly the first one, because the Neonatal Care Leave and Pay Bill will only be relevant to a limited number of working parents. The precise details of this will be set out in new regulations, but broadly, the bill will create a new day one right to take at least 1 week and a maximum of 12 weeks neonatal leave if the baby needs to spend time in neonatal care. There'll be a statutory rate of pay for those that have at least 26 weeks service. Now, the new right to, and I should mention that the third reading of that bill is taking place this Friday, 3rd of February, so that's one to look out for. And the carers leave bill is likely to be relevant to a wider range of employees. So this is a day one right for employees to 1 week's unpaid leave to care for a dependent with a long-term care need. And this differs to time off for dependents leave, which exists already, because that's available for emergency caring situations, whereas this is intended to cover planned and foreseen caring commitments, and therefore it's going to have a minimum notice period requirement. Long-term care need is defined in the bill to cover illness that requires or is likely to require care for more than 3 months, or a disability under the Equality Act, or care for a reason connected with old age. Now, employees won't need to provide evidence of how the leave is used or which dependent it's going to be used for, but employers may still want to ask the question. So a policy around this or self-certification process is likely to be a good idea to address that. And again, the details are going to be set out in regulations, but broadly speaking, the leave can be taken either in increments or in one batch, but the total entitlement will be 5 working days over a 12-month period. Now, it remains to be seen how popular this will be because it is an unpaid right, but some employers may decide to add this into the mix with the other family leave that they offer and offer full pay for either some or part of the leave entitlement. And regulations for this bill are expected to commence in 2024. Next slide, please. Now, you may have seen the numerous critical press and industry articles about the retained EU law Revocation and Reform bill. This has just been through its 3rd reading and report stage in the House of Commons, and it's now at the 2nd reading in the House of Lords. And the consternation is due to the current sunset date of the 31st of December 2023 that's included in the bill. And what that sunset date means is that huge swathes of UK law, which are derived from EU law, and this is across many areas, not just employment law, would automatically expire on that sunset date unless the UK government takes proactive steps to retain the laws. There's been press reports which suggest that the government might push back the sunset date to a date in 2026 in response to the opposition that's expected in the House of Lords, but that remains to be seen. Now, from a employer's perspective, there are several regulations which would be affected by the blanket sunsetting provision. We've included a list of potentially effective regulations on the slide, but it seems more likely that the government will eventually turn its attention to specific areas of reform rather than wiping out these regulations in full and starting again, particularly given the obvious uncertainty that that's going to cause employers and businesses. But parts of the working time regulations may be a prime candidate for overhaul. For example, the method of calculating holiday pay or the obligation to report working time, which is often ignored. And just to mention briefly on cheaply, I mean, it seems highly unlikely that the government's going to scrap cheaply altogether, particularly given the established body of case law and the fact that many businesses have clarity when it comes to employment implications of business transfers and the contract tendering process. So for now, it's a definite watch this space when it comes to this bill, and we're going to publish updates in HRLaw as the situation develops. And I should say that if you're not familiar with HRLaw, which is where we publish our employment law articles, then please do check that out. Next slide, please. So finally, I just want to quickly mention some other potential developments that are expected this year. The first is the Strike Minimum Service Levels Bill. This was introduced to Parliament on the 10th of January this year in light of significant ongoing levels of industrial action across a range of public services. And the bill enables regulations to be made which set minimum levels of standards, levels of service, in particular in specified public services such as rail, ambulance, fire and rescue, and also education, border security, and nuclear decommissioning, so that those services don't completely shut down when there are strikes. And the government intends to consult during the passage of the bill on what an adequate level of coverage looks like in fire, ambulance, and rail services. And then for the other sectors, it's hoping that agreement can be reached on minimum service levels. Next is the statutory code of practice on fire and rehire. So a draft code of practice was published last week as part of a consultation, which is going to run until the 18th of April. The code will set out employers' responsibilities when seeking to change contractual terms and conditions of employment, where it envisages that if the employees don't agree, it might seek to dismiss them and offer to rehire them on those terms. And the steps include that businesses must provide as much information as reasonably possible whilst engaging in meaningful and good faith consultation for as long as possible and exploring alternatives. Now, where this kind of has its main bite is that tribunals would be required to take the new code into account when considering the fairness of dismissals in this context, and they'll have the power to uplift compensation by up to 25% if an employer fails to comply with the code. So in essence, that mirrors the current approach which is taken in relation to the statutory ACAS code on disciplinary and grievance procedures. Next, we've got the government consultation on calculating holiday for part-year and irregular hours workers. So this has already been launched and it closes on the 9th of March 2023. It proposes introducing a 52-week holiday entitlement reference period, which includes weeks in which no work is done, to ensure that holiday entitlement and pay is directly proportionate to time spent working. And finally, I'll just briefly mention the PRA and FCA consultation on removing the banker's bonus cap. That closes on the 31st of March this year. Now, you may be aware that the effect of the current cap is to limit the size of certain employees' bonuses so that it's no bigger than 100% of their fixed annual pay, or 200% if there's approval from shareholders. The main argument that's been put forward in removal of the regulatory cap is that in practice it simply resulted in an increase in fixed compensation to account for the cap on bonuses. And as I say, that consultation's open till the 31st of March. We've written about this previously in HRLaw, so do have a read of that if you haven't already. Thank you, that's all from me. So I'm going to hand back over to Jo so that we can address some of the questions that have been asked.
Thank you very much, Lucy and Imtiaz. As you can see, it's quite confusing in our team because we've got two Lucy S's who've joined us. But thank you all for your thoughts this morning. We do have a number of questions. Before we go into these, Lucy mentioned the HRLaw articles. You can find those on our website, but if you or any of your colleagues would like to subscribe to receive those to your mailbox, please let your normal Fox Williams contact know, or you can email me and we'll get you and any colleagues that you would like to also receive them onto the mailing list. We're going to start with a question, I think, for you, Imtiaz. What are the measures that employers can take if they notice a detriment on an employee as a result of them having a second job? If it affects performance in the main job, but they need the financial benefit, then what?
Thanks, Jo. Thank you for the question. It's a bit of a tricky one because on the one hand, obviously they're your employee and they have duties to you under the employment contract. And it's likely that you have restrictions in the contract which restrict or prohibit a second job. But obviously, given the circumstances, you might want to be sympathetic to the fact that they may need more income. I think in the first case, you should address any concerns that you might have with the employee, and then it's up to you, how far you accommodate the second job by making adjustments. to their working day. So for example, you might consider different start or end times, more home working, but there's no real positive duty to do this. It might be the case that the employee is more inclined to do a second job, which utilizes their skills, so in a similar industry. But actually, as an employer, you might be more likely to be sympathetic or accommodating if the second job isn't in the same industry, it's not competing with their day job. Ultimately, it's up to you, to be honest. But if performance continues to decline, then you might need a formal process to address any concerns.
Brilliant. Thank you, Imtiaz. Some questions for you, Lucy, Sorrel. Is the generous ex gratia payment the best way to avoid future claims?
I think it can help on a practical level, because arguably, if an individual has a more generous ex gratia payment, then they're not going to be as motivated to bring a claim. But I think legally it doesn't make any difference, because I think the point that we're discussing is that is the claim kind of in the contemplation of the parties at the time that they're signing the agreement, have the facts giving rise to a claim occurred. And if that's not the case, then a larger payment won't do anything kind of from a legal perspective to change that. So I think practically, maybe, legally, not really, is the answer to that.
Brilliant, thank you. And then can you explain the difference between without prejudice and protected conversation?
Yeah, so without prejudice conversations protect discussions in relation to settlement of discrimination claims and a whole range of other claims. Protected conversations only in relation to discussions which attempt to settle unfair dismissal claims. Also, with protected conversations, there's no requirement for the parties to be in dispute, as there is with the without prejudice rule. So, and there's kind of a lower bar to set up a protected conversation, in that you don't have that requirement for a dispute, but it only covers the unfair dismissal claims, whereas without prejudice is wider in application.
Yeah, I mean, the protected conversation regime was introduced to overcome that issue around there needing to be a dispute. So that's going to be essentially what it's designed to do. Brilliant. So one further question, I think I can answer, but it's whether you'll receive a recording of this webinar. We are recording the webinar, and we can share it. We intend to share it with those who haven't been able to join us this morning. But if you would like to receive a recording, please let me or Eva know, and we can arrange for that to be sent out to you. So I think with a couple of minutes to spare, unless anyone's got any other questions they want to pop into the box, it just remains for me to say thank you very much for attending this morning. I hope you all found it really useful. There's clearly a lot in the pipeline that we need to look out for, and as we've mentioned, that will all be dealt with in good time, so you have forewarning of things as soon as we know about them through HRLaw, and we'll obviously be covering some of the things in these webinars throughout the year. And thank you also to the speakers this morning in their first appearance. I'm sure you're going to be seeing a lot more of them in later sessions and other sessions that we run. So thank you to Imtiaz, Lucy and Lucy for this morning. Have a great day, everyone. Thanks for joining us.